Well, now I give the floor to the Counsel for the Defense for his concluding statement. We have 45 minutes. Please, the floor is yours.
Je vous remercie, Monsieur le Président.
Your Honour. I seem to recall that at the beginning of this hearing, I talked about the critical situation of defence, the only voice facing all of you and the representatives of victims. I now have 45 minutes, during which time I will try to respond to what we have heard from the Office of the Prosecutor and the representatives of the victims. I will start with the question that you asked regarding the surrounding areas and the attempt to provide clarification on behalf of the Office of the Prosecutor. I say attempt because I don't know about you, but things were not made much clearer for me with regard to surrounding areas. Once I had heard this clarification, it was no clearer than before. The Deputy Prosecutor spoke of Delair and Mouza and the environs, saying that there was no clear site for the executions, and we understand that, of course. But at the same time, he spoke, and that's in paragraph 226 of the brief, the PCB. He also spoke about Tendi, which is one of the locations specifically excluded from paragraph 5 of the DCC. I will try and summarize what I understand and say that for Delair and Mouza, for the prosecutor, it's important that the victims were there, that they were held there, no matter where they came from and where they were executed later. But the question of the other locations remains open, and we have no further news on the Kudum and Vindisi. Tendi is both a location included in the surrounding areas of Mouza in paragraph 226, yet still a location excluded from the charges in paragraph 5 of the DCC. The OTP has tried to reintroduce proof, evidence, with regard to the identity of Mr. Ali Abd-Al-Rahman and Ali Kouchaib. This was done in a number of stages, which I would like to run through now. Firstly, it was stated that our point of departure was the same. Mr. Abd-Al-Rahman was in the army in the past. He left as a warrant officer. He, at the time of the fact, was a pharmacist in Gassina, and the OTP agreed for the first time to the information provided by the defense, and we thank you for that. The OTP admitted that Mr. Abd-Al-Rahman joined the police reserve in 2005. That's fine. 2005, which is, of course, after the events. The OTP legitimately asked the question, well, Ali Mohammed Abd-Al-Rahman left the army as a warrant officer and as a pharmacist in Garcia, and he spent a long time as a pharmacist in Garcia, and that is a good basis to try and establish identity between the two. I come back to the work of Ms. Flint that I said, that I quoted earlier, and after the facts, we rewrote history. We rewrote history in a way that puts the responsibility for the crimes on to others other than those who were responsible for the crimes, so that the crimes would not be investigated. And when you do that, it is wise to base this rewriting of history on some clear events. They chose the accused, Mr. Ali Abd-Al-Rahman, to be a certain Ali Kouchaib, saying that both were former warrant officers and former pharmacists at Garcia, which is quite true. And on the basis of this, history could be rewritten. I understand that my strategy was described as conspiracy-based, but I didn't say that. It was Madame Flint, Ms. Flint, who described that in Sudan. The OTP cited a number of witnesses saying that they were capable. I mean, we haven't heard any witnesses, which is a great pity, but I mean, let's leave that to one side. But we've been assured that if we'd heard these witnesses, they would have been able to confirm it. P177, sorry, I've missed the reference. He says on 0071 of the document that Mr. Ali Kouchaib used to work in administrative units of medical treatment. Well, for a military chief, well, that he was recruited in the PPF. We've never heard anything of this from the OTP, that he came from the Abaniya tribe. Wrong, Taisha. And because he was part of the counterinsurgency, he had received a military rank in the PPF. This was not mentioned by the OTP, so presumably there was not much credence given to this witness, as he was not quoted. And finally, on the subject of this witness 177, he identified Mr. Abd-Al-Rahman on the basis of the photo of the court, which was on the site for Ali Kouchaib wearing a white turban. And it's a photo that's been seen on the court site and elsewhere, so it's difficult to disagree with this photo. Similar identification is common to P769, which was from 2018. So this was to do with accusing Mr. Abd-Al-Rahman under the pseudonym Ali Kosheb. And this witness said that he never met Ali Kosheb in person. And this witness says to us that the Popular Defense Forces were excluded from the counter-insurgency because they were mostly Darfuri. And this witness also produces and comments on 02154658, a document talks about a transfer of I don't know how many vehicles, heavy weapons and what have you, to Mr. Abd-Al-Rahman on the 6th of November 2005, at which time, as the OTP recognized earlier, Mr. Abd-Al-Rahman had joined the police reserve as a new recruit. I don't think the prosecution can have much credence in this witness either, because it's not included in the PCB. Another witness giving her evidence, not direct evidence, talks about Ali Kosheb at Garcia. 01250002. Ali Kosheb is the coordinator of the PDF, says the prosecutor. But again, he's not quoted in footnote number 1 of the brief. Therefore, that also is indicative of the level of credence, level of credibility. Another witness who speaks of the huge transfer of money, the 480 plus several zeros, which took place in the early or in the mid 2000s. That is there is doubt, but let's say that it's likely to be after the facts. Roughly at the time when Mr. Al-Rahman is following the training that allows him to join the police, or has joined as a new recruit. Perhaps the Sudanese government is very generous, giving 480 plus several zeros of money to them. And then P883 in DAR OTP 0218 0059 explains that. But I don't know what to call him. Abd-Al-Rahman Ali Kosheb was deployed in the Army Medical Corps, that he became a master sergeant. I'll leave it at that name. And that there he acquired the reputation of being a fearless warrior. None of these witnesses is quoted in footnote 1 of the prosecution, which is the page devoted to this matter. Perhaps their credibility is deemed limited, and this is why I feel that the prosecution did not want to include them. There was another argument from the OTP, which is profoundly irritating. The OTP says, well, the victims say the same thing.
Aucune victime n'a dit
No
Monsieur
victim has said that Mr.
n'était
Abd-Al-Rahman
pas Ali Kouchaïb.
was not Ali Kouchaib.
Alors, je dirais au bureau du procureur
So,
sur ce point
I would say to the OTP on this point
afin de ne pas
that
prendre le risque de commettre la moindre offense ou ce qui pourrait être décrit comme
without
offense
wishing to cause
à l'égard des
any
victimes,
offence to the victims or any presumed offence to the victim, I would refer them to the writings on the reparations.
de la
The,
décision sur la culpabilité
there are reasons why reparations and the culpability need to be treated as separate questions.
l'une par l'autre, les victimes
As long as they remain
quoi qu'elles en
linked,
pensent, n'ont pas d'autre
the victims have no choice
le bureau du
but
procureur
to support the ODP in the hope of a conviction which could lead to reparation. They merit more than that, given what they've gone through, and to link reparations to conviction so that they can finally achieve something is really not acceptable.
la vidéo.
And then we have this video,
Je vais mettre ensemble avec
which I will
la
link
vidéo et la
to
référence.
the video and the reference to the registry
Ces éléments-là ont
report.
déjà été répondus dans
These
l'écriture de la défense,
have already
CST
been
0205,
responded to in defense
0120,
submission,
235,
and I apologize for not getting the reference.
paragraphe 34 à
But
35
it's
pour ce qui
34,
concerne la vidéo et
35 for the
37,
video
pour ce qui concerne le
and
reste.
37, 38 for the registry.
Rappelons-nous du contexte.
Let us recall the context.
En 2007,
In
la Cour a
2007,
délivré un mandat d'arrêt
the court issued an arrest warrant against Ali Kouchaib.
Le nom est le seul sur le mandat
That
d'arrêt.
is the only name
apparaît
on
dans
the
l'intitulé de l'affaire,
arrest
c'est-à-dire
warrant. The name Abd-Al-Rahman
Et
appears as
suite
technically
à ce mandat
in
d'arrêt,
the case name,
la
but
totalité
and then
de la
in
communication
this
officielle du bureau du
arrest warrant,
procureur ou de
all the
ne se réfère
communications
qu'à
speak
Ali Kouchaïb.
only of Ali
Abd-Al-Rahman
Kouchaib.
n'est nulle part.
No mention at all of Abd-Al-Rahman.
Remettons-nous aussi dans le contexte.
So let's come back to the context. As the OTP accepted
A
Mr.
entrepris
Abd-Al-Rahman
de sa propre initiative
from his own initiative, took a long and difficult journey
du Soudan, Riyad al-Baldi,
from
de sa
Sudan, the place of his last residence,
jusqu'en République centrafricaine.
to the Central
À
African
ces risques et
Republic.
périls, pour quelles raisons entreprend-il ce voyage?
Why did he undertake this difficult
Il
journey?
entreprend ce voyage parce qu'il
He
est informé
did this because he was informed that
des autorités soudanaises
the Sudanese authorities
envisagent de l'arrêter parce qu'il est
intended to
en tant
uh,
Ali Kouchaïb
arrest him because the International Criminal Court was seeking him as Ali Kouchaib.
Monsieur Abd-Al-Rahman travaille dans la
Mr.
police.
Abd-Rahman works for the police.
Il est bien placé pour
He's in a
connaître
good position
les prisons soudanaises,
to be familiar
Bien
with
placé.
Sudanese prisons.
pour connaître les raisons qu'ils font qu'il n'a aucune envie de s'y retrouver.
He knows very well why he has no desire to spend any time there. So,
Et d'aller à la
better to
rencontre de-
go and to go towards the court in the Central African Republic, and in that
Là est faite.
context, this video was taken.
Au moment où il filme,
And he knows when he filmed this video,
pardon, il croit,
or he believes,
au moment où il fait cette vidéo,
when taking this video, that the court only knows him under the alias Ali Kouchaib, because all the court's communications and even the arrest warrant use only this name.
Donc, lors de la comparution initiale, Monsieur Ali
So,
Mohamed Ali Abd-Al-Rahman vous dit
During the
qu'il est
initial
venu à la
hearing,
Cour pénale internationale
he says he came to the International Criminal Court
Monsieur Ali
to
Mohamed
find
Ali
justice.
Abd-Al-Rahman,
Mr. Ali Mohammed Ali Abd-Al-Rahman
besoin
is
d'être pris en charge par la Cour. Il ne sait pas qu'il va être arrêté.
needs to be taken on by the court. He doesn't know whether he's going to be arrested. How will that happen? He had no idea what would happen to him at that stage. But he needs to put himself under the control of the court. And therefore, he needs to make himself known, and he needs to make himself known by the name by which the court knows him, of Ali Kouchaib. As well as putting this into context, I would refer to the case law of this court in the Katanga case.
En date du 19 décembre 2010, au paragraphe 62 et 63 que je vais lire.
ICC 104072635 of December 2010, and it relates to Article 61G. I quote. I'm sorry, this has been quoted far too fast. I cannot follow it. Yes. I apologize from the interpreter's booth. And the speaker apologizes to the interpreters. The Chamber considers that what is important in the right of a counsel in pre-confirmation briefs is to protect the right of the accused, who is to be presumed innocent, to remain silent and to not contribute to his own incrimination. Even if the counsel is not physically present, the rights of the accused may, under certain conditions, be sufficiently protected, and this came into an appropriate opinion before the examination. One condition is that there must be no constraint put on the accused during the examination. Constraint? No, that's not our defense. Even though the forced departure from Sudan in itself does represent a sort of constraint, not from the court, but from the prosecution. And now, appropriate, well, in the middle of a Central African Republic forest, I think it could be said that reasonably this was not possible for him. And the right to silence, to get this respected in these conditions, you will understand that the OTP has the decency not to use this video clip. In our submissions, this was made known to the ATP, and this was not mentioned in the brief. We thought that this matter was now closed, but when faced with an emergency, the video reappears. In a decision from the Rwanda Tribunal, from Nirando case, decision on the Wadia accused of the accused. In the case in question, the accused gave to the OTP, without knowing that he might be prosecuted, his CV, and the OTP took the CV, but later attempted to introduce this as evidence of a CV that had been voluntarily submitted. The Chamber observes that the Office of the Prosecutor had not informed the accused of his rights, that the accused did not use the right to have a counsel when submitting the CV. And so it would be antithetical to and seriously damage the integrity of the proceedings to admit the CV in question. I believe that the same words could be used here, antithetical to and contrary to the proceedings. And in the same sense, I would quote a decision by an extraordinary chamber in the Cambodian Tribunal Duke, a decision on the admissibility of material of the case file as evidence, and that was from 2009, May 2009. (00018-07 2007), name of the court. I will not provide any further references, but I would just like to say that it is most regrettable that the prosecutor showed this video in these conditions. And I'm sorry, you can't take the registry as a witness. The registry report cannot be used in this way. The defense has daily contact with the registry for all types of support, communication with the accused. And can I really take seriously this idea? I think that smacks of desperation. The OTP tried to put to one side Colonel Linda Strait-Murnane, saying that she was a hypothetical expert during a hypothetical conflict in a hypothetical country. I have two things to say in reply. Colonel Murnane is an expert. She's not a witness. And she has shared her immense knowledge in the area, partly from her US military career and partly on the basis of her career in the ICTY and the Special Tribunal for Lebanon. These qualifications were not contested by the OTP. It is important to distinguish between a witness and an expert. And now the investigations. In reply to the understandable request, the ATP says that they will carry out new investigations, new charges if necessary, and to put this goes Rule 2223. Looking at this, we have discovered a number of charges for which the defense had never seen any notification since the arrival of Mr. Abd-Al-Rahman at the court. And therefore we requested that these all be rejected because of an absence of notification. I won't dwell on this. It's a matter you're dealing with, Your Honours. And so the investigation can continue if the charges are confirmed, and that would be in the phases preliminary to the trial. But that would be a part of the trial. So that's all I want to say on the observations of the OTP. How much time do I have left, Your Honour?
Court officer?
Your Honours, the defense have 18 minutes to go.
10 minutes?
1-8.
1-8. Thank you.
Mr. Nikos, do you want to say anything?
Apologize, Your Honors. Again, not an objection, but just to correct a portion of the transcript. It was said that I called Ms. Murnane a hypothetical expert. That is not correct. What I said is at page 53, line 12 of today. I used the word hypothetical, but not in relation to Ms. Murnane.
Confrère,
Thank you.
vous avez tout à fait raison. Et je
Mr. Lauchi, my learned friends, you are entirely right in so saying, and I correct what I says. The hypothesis was on the substance and not on the identity of the individual. Thank you.
This is not a problem. It is noted in the records. Please continue.
À propos de nouvelles
Mr. Lauchi, now, with regard to newly received documents without prior notice, we received one from the distinguished member of the LRV team on the other meaning of the word kushayib, which means Tau fact fighter. That is to say, a hard-headed fighter. So, you told us, Madam Legal Representative for Victims, that we should have been in the know. And I would answer you by saying that this is all news to us. How would we have been in the know? What is more, I would note that the Office of the Prosecutor did not know itself, because the explanation that it furnished was indeed the one that the defense referred to and responded to, that is the one of alcohol. So this is a new item or element that you give no substantial evidence underpinning it, and I believe that it should be set to one side. Now, as to the richness associated with the defendant, you repeated on a number of occasions that rich people in Sudan could be counted on the number of heads of livestock, and I agree entirely with that. How many heads of livestock does Mr. Ali Abd-Al-Rahman have? He and his family? Well, at the time when he left Sudan, the family had 2 cows, one of which died. So only one is remaining, and that information was not in your possession, but it is, I believe, in the classified documents, and it is in the court file, and the chamber has it in its possession. Now, you compared this with Mr. Emeti, or you compared this with Mr. Emeti, who is not an AKA or alias. He is not a Nazir, but he is the grandson of a Nazir, according to Madame Fleet, and from a different tribe entirely. Now, as to the origin of said person's richness, I have no idea whatsoever, but the onus of evidence is not on my back. But all I can say to you is that Mr. Ali Abd-Rahman was no rich man. He had 13 euros a day in terms of salary in 2010, and with the devaluation, it is now down to €1.30. Now, as to the title of Colonel of Colonels, this title, Colonel of Colonels, you explained to us is a tribal title that might have been obtained spontaneously in a generational sense. Okay, fine. However, the OTP's file says something quite different. Their case says something quite different. That this is one of the proposals on the agreed facts, proposal number 9, that was refused by the defense.
At least April 2004, the parties to the armed conflict on both sides were well organized and armed. Je vous renvoie sur l'absence.
I would refer you to the absence of description on the part of the Office of the Prosecutor for chains of command, for structure, for details on this mysterious organization, that is to say, the Janjaweed. And to draw the simple conclusion that the evidence is not in the file, and if it's not there, well, the charges should be set aside. Paragraph 305 of the decision, the Katanga decision 717,
la Chambre
the Chamber
y écrit
writes, and I quote,
pour que l'homicide intentionnel
for
constitue un crime de guerre,
intentional homicide to be a war crime under Article 821 of the statute, the perpetrator also has to know the far too fast. The Council is quoting far too fast, impossible to interpret.
connaissance.
You need to go slower.
Pardon. Merci. Je reprends la citation.
Mr. Lauchi is going to repeat, quote, Katanga 717 paragraph.
Pour que l'homicide
For
intentionnel
intentional homicide to constitute a war crime
au sens de l'article
under Article 82A1 of the statute,
faut également que l'auteur
the perpetrator also has to have the knowledge of the circumstances, the factual circumstances establishing the status of protected individual of the victim.
je ne dis rien d'autre.
I would say nothing further on the subject.
Par conséquent,
As a result,
il n'est pas
the Chamber
nécessaire
continues
que
to
l'auteur
say that it is not necessary for the perpetrator to have assessed the situation and have reached the conclusion that the individual or victim has indeed the statute of protected person. Yes, of course, we're not asking for the perpetrator or the suspect to deduce.
d'avoir
We are asking him to have knowledge.
exactement
And that is exactly what the defense and the chamber in the Katanga case
de concert.
said in unison.
La distinguée représentante des
The distinguished legal representative for victims, Ms. Clooney,
nous a demandé,
asked us
selon la défense,
if,
s'il y
according
aurait
to the
quelque
defense,
part en ce monde
there would be somewhere in this world another Ali Kushaib,
je vais vous répondre avec
and I will ask,
que je n'en sais rien.
answer that question in the most humble manner possible,
Pas à moi de le dire.
that I do not know and that it is not up to me to say.
Vous nous avez proposé
You
d'utiliser
suggested to
une
us
défense d'alibi
that we use an alibi defense to say that he's a pharmacist in Garcila and that he was selling medication. We did not defend or develop an alibi defense because we were not in a position to go and gather evidence of any possible alibi in Sudan. And I'm not complaining about that. It is a fact.
Nous aurions bien aimé
We would have liked to go there.
pouvoir présenter un alibi
I can assure you, we would have liked to present a defense alibi, an alibi of defense, but we were not able to go.
porter une certaine responsabilité
The
historique
prosecutor
d'avoir engagé des
has certain historical obligations, having commenced prosecutions without having reached an agreement as the statute requests, but we were not able to do so.
mes réponses.
Now, I have finished providing my responses, and I now come to my conclusion.
Nous sommes à la fin de
We are at the end of the confirmation of charges hearing,
au tout début.
and at the very outset of the hearing, in my preliminary comments, 1, 2, 2, 3, that is, I regretted that the pretrial chamber 2 has on occasion retained a limited or restrained concept of the rights of the defense in the pretrial phase in a number of its decisions.
Ce regret m'amène
This regret
à
brings me
demander
to ask you solemnly
d'exercer pleinement
to fully exercise
chambre préliminaire
your functions as pretrial chamber,
consiste
which consist in the selection of cases presented by the Office of the Prosecutor, which are sufficiently
lesquels il y a suffisamment de
ready and solid, for which there is enough evidence to take the heavy decision to commit an individual to trial,
des mois,
which means
des années de procédure
years or months of procedure during which the individual, and I'm talking here in terms of probability and statistics uniquely, will remain in detention. And if there are no charges, then there are consequences. That is the request that I am addressing to you. Now, last of all, I will finish off with the pharmacist from Garcella. The pharmacist comes, or term pharmacist comes from the Greek pharmakos, and pharmakos had two meanings, or has two meanings in the Greek language. And in the past, this might have meant somebody who delivered medications, but it means the person who is immolated in the expiation of the errors of another individual, giving rise in our language of the modern day to the word scapegoat. Where does that word scapegoat come? Well, we also need to go through the Greek language to find the origin of this word. The scapegoat is the Greek translation of bouc pour Azazel. And bouc pour Azazel comes directly from chapter 16, verses 21 to 22. Aaron put his two hands on the head of the living goat, and he will confess to him all the iniquities of the children of Israel and all the transgressions via which they have sinned. He shall put them on the head of the billy goat, and he will drive him away into the desert with the assistance of an individual whose job it will be. The billy goat will take with him all their inequalities into a desolate environment. He will be chased away into the desert. End of quote. I took this passage and read it to you because I wanted to compare this with what Madame Julie Flint said to us, a very great expert on the Sudanese conflict in the year 2009. And after the crimes in Sudan, history was rewritten, and the responsibility for the crimes was put on certain individuals with a view to ensuring that the true people responsible remain unpunished. Mr. Ali Abd-Al-Rahman is a Taisha. He belongs to one of those tribes that has refused the call to the tribal militia. He has refused to take part in the counterinsurgency in which all the crimes described by the Office of the Prosecutor to us have been committed. There is for sure one other reason. He's not the only Taisha in Darfur. There is probably one other reason why he was targeted and designated as being Ali Kushaib. We do not know what they are, these reasons. What is the most important thing to us is that the Office of the Prosecutor has not borne the evidence that Mr. Ali Abd-Al-Rahman could or can be Mr. Ali Kushaib and has or had exercised the authority to commit the crimes contained in the document containing the charges. And it is on this basic observation that I request that the pretrial chamber decline the charges or in their totality. Thank you.
Thank you very much, Mr. Counsel. Now, with the concluding statements of the defense, we come to the end of the confirmation of charges hearing. The decision on the confirmation of charges against Mr. Abd-Al-Rahman will be delivered in due course. We will be seeing, all being well, tomorrow morning at 9:30 for the detention hearing with the same parties and participants. Before closing, I would like to thank very much the parties, the participants, and very, very much the interpreters, the court reporters, technicians, security officers, and all registry staff for the timely and professional cooperation. I wish everyone a pleasant afternoon and evening, and the hearing is adjourned. Thank you very much.
All rise. Veuillez vous lever.